In a recent development that has captured national attention, political discourse around birthright citizenship has intensified dramatically. For those unfamiliar with the term, birthright citizenship refers to the 14th Amendment guarantee that anyone born on American soil automatically becomes a United States citizen regardless of their parents' immigration status. This principle has been a cornerstone of American identity since 1868 following the Civil War. However, according to sources, there are now serious discussions within policy circles about reinterpreting or potentially challenging this constitutional provision. Reports suggest that proposals being floated would restrict automatic citizenship to children born to at least one parent who is either a United States citizen or lawful permanent resident. What makes this case different is the scale and speed at which these discussions are progressing, with speculation suggesting implementation could begin as early as 2026. The landscape of American immigration has always been subject to political winds, but this proposal represents something, really unprecedented. Officials argue that the current interpretation of birthright citizenship was never intended to cover children of temporary visitors or undocumented immigrants. They claim that the phrase subject to the jurisdiction thereof in the 14th Amendment provides room for reinterpretation. Immigration experts note that this reading conflicts with over 150 years of legal precedent and Supreme Court decisions. In a recent statement, proponents of the change declared that birthright citizenship has become a magnet for what they call birth tourism, where foreign nationals specifically travel to the United States to give birth and secure American citizenship for their children. Critics, however, warned that such changes would create a permanent underclass of stateless children born in America, but denied citizenship rights. To put this in perspective, let's examine who would be affected by these proposed changes. The impact would be staggering and far-reaching. Children born to parents on temporary visas, including students on F-1 visas, workers on H-1B visas, and visitors on B-1 or B-2 tourist visas, would no longer automatically receive citizenship. Children born to parents in the asylum application process, or those with pending immigration cases, would face uncertain status. Even children born to green card applicants who are in the United States on temporary status while waiting for their immigrant visa processing would potentially be excluded. Perhaps most controversially, children born to undocumented immigrants would be denied citizenship despite being born on American soil. This means that hundreds of thousands of children born annually in the United States could suddenly find themselves without a clear path to citizenship in the country of their birth. According to sources, the administration behind these proposals argues that modern birthright citizenship policies are being exploited, and that the United States is one of the few developed nations that still grants automatic citizenship based solely on place of birth. They point to countries like the United Kingdom, Australia, and several European nations that have moved away from unrestricted birthright citizenship. The administration claims that limiting birthright citizenship would reduce illegal immigration incentives and prevent birth tourism abuses. However, legal analysts suggest that implementing such changes faces enormous constitutional hurdles. What this translates to in practical terms is a potential immigration crisis of unprecedented proportions. Here's what you need to know about the cascading effects. First, consider the documentation nightmare that would ensue. Currently, a United States birth certificate is sufficient proof of citizenship. Under the proposed changes, children would need to prove their parents' immigration status at the time of birth. This would require maintaining and verifying complex immigration records for generations. Hospitals and state vital records offices would need to collect and verify parental immigration status before issuing birth certificates. The bureaucratic burden on the already overwhelmed USCIS system would be immense. Despite these challenges, proponents of birthright citizenship changes argue that the United States needs to align its policies with international norms. They argue it represents a tiny fraction of births and doesn't justify dismantling a constitutional guarantee that has served America for over 150 years. While there have been some modifications to immigration enforcement and policy over recent years, this proposal represents, honestly, a quantum leap in scope and impact. Let's take a closer look at the timeline and potential implementation. According to sources, if the proposal moves forward, it would likely begin with an executive order challenging the current interpretation of the 14th Amendment. This would almost certainly trigger immediate legal challenges from civil rights organizations, state attorneys general, and immigrant advocacy groups. Legal analysts suggest that the case would quickly reach the Supreme Court, where the outcome remains, well, uncertain. The court's composition and judicial philosophy would play a crucial role in determining whether such a reinterpretation of the 14th Amendment could stand. The real question is what happens during the interim period between policy announcement and final legal resolution. Immigration experts warned that this uncertainty could last years, creating a kind of limbo status for children born during this time. Would birth certificates issued during legal challenges be valid? Would these children be able to obtain passports, social security numbers, or access public education? Would they be deportable once they reach adulthood if the policy is ultimately upheld? These questions remain unanswered, adding to the anxiety felt by immigrant families. However, before jumping to conclusions, it's important to understand the political and legal landscape that makes implementation far from certain. Congress would likely need to be involved for any permanent change, and achieving the two-thirds majority required for a constitutional amendment appears nearly impossible in the current political climate. Additionally, several states have already indicated they would refuse to comply with any executive order restricting birthright citizenship, setting up a potential states' rights battle reminiscent of other contentious policy disputes. California, New York, and Illinois, among others, have historically protected immigrant rights and would likely continue issuing birth certificates affirming citizenship regardless of federal directives. What makes this situation particularly complex is the intersection with other immigration processes. Consider the family-based immigration system, which relies heavily on United States citizen children petitioning for their parents once they turn 21. If birthright citizenship is restricted, this pathway would effectively close for many families. The EB immigrant visa categories, including EB1, EB2, EB3, EB4, and EB5, could see increased demand as families seek alternative paths to permanent residence. Similarly, family immigrant visas for immediate relatives of United States citizens would face longer backlogs as the pool of potential petitioners shrinks. Processing times, which already stretch from 14 to 16 months for many categories, could extend even further. In practical terms, anyone currently in the United States on a temporary visa and expecting a child needs to understand the potential implications. If you're on an H-1B or L-1 work visa, your child born today is a United States citizen. Your child born in 2026 or later might not be, depending on how these policy discussions unfold. This creates urgent pressure for families to consider their options. Some are exploring acceleration of their green card applications through premium processing where available. Others are consulting immigration attorneys about whether to delay family planning until their own citizenship is secured. These deeply personal decisions are now being influenced by policy uncertainty in ways that seem fundamentally at odds with American values. Advocacy groups warned that restricting birthright citizenship would particularly harm mixed-status families where, some members are citizens while others are not. Currently, a United States citizen child creates certain protections against deportation for their parents in some circumstances. Without birthright citizenship, entire families could become deportable, even if they've lived in America for years. The emotional and practical toll of such policies would be devastating. Immigration experts note that countries that have restricted birthright citizenship have seen increases in stateless children, individuals who belong to no country and have no legal protections. Creating such a population in America would be a humanitarian disaster and, honestly, a stain on the nation's legacy. To put the scale of this change in perspective, approximately 300,000 children are born annually to parents who are not United States citizens or legal permanent residents. If birthright citizenship restrictions take effect in 2026 and remain in place, within just 10 years, 3 million children born in America would lack citizenship. Within a generation, tens of millions of American-born residents would be classified as non-citizens, fundamentally changing the demographic and social fabric of the nation. The long-term consequences are difficult to fully comprehend, but they would undoubtedly reshape American identity in profound ways. That's all we have for this bulletin. The situation surrounding birthright citizenship remains fluid and highly contested. While proposed changes have generated significant attention and concern, substantial legal and political hurdles remain before any modifications could take effect. For immigrant families, the key is staying informed, consulting with qualified immigration attorneys, and understanding your rights under current law. The United States Immigration Hub channel provides all necessary visa information and procedures for your United States immigration journey. It is important to understand United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about United States visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas,